The West Virginia Law Review's second lecture in our three-part series, Beyond Politics, a discussion of healthcare in America. For all of you who are attending in person, and for all of those tuning in online, you have chosen a fantastic way to spend your next hour, even if I am a little biased. I had the opportunity to spend yesterday evening with Professor Dayna Matthew, today's lecturer, and I have no doubt that today's lecture will be amazing. Before I begin today, I would like to just extend a few thank yous. I would like to thank Dean Joyce McConnell for all of her assistance in this process, Dean Valerie Vidic for all of her help, Professor Ashdown, who is the Law Review's advisor, and I would especially like to thank Andrea Johnson and Todd Bergstrom, who are the executive editors that are completely responsible for the entire design and direction of this lecture series. This lecture series is about healthcare, but it's about more than healthcare. In fact, this lecture series is about our society's conception of fairness and justice. This series is intended to shine a light on those who are left out of the system and those who are denied proper care. Today's lecture will continue the West Virginia Law Review's goal in examining fairness and inequities in our current system. In our first lecture, presented by Professor Eleanor Kinney of the University of Indiana, we kicked off the series with a discussion on the role of for-profit industry and how the for-profit capitalistic model impacts the universal human right to health. Today's lecture, Fiduciary Solutions to Healthcare Disparities in America, presented by Professor Dayna Matthew of the University of Colorado Law School, will focus on racial and ethnic disparities in healthcare. Professor Matthew will show how racism and race bias can manifest itself in unconscious ways, and how unconscious acts of racism in America's healthcare system can lead to great disparities. Professor Matthew's lecture, though, will not just highlight the problems in our system, but will seek to offer a solution. The purpose of today's lecture, and the lecture series itself, is to spotlight the intersection of the law and society, to show how the law is more than statutes and judicial opinions documented in old books. The purpose of this series is to show that an exploration of the law is meaningless unless we also discuss those who are touched by it, people who are the real crux of our laws. In Professor Matthew's presentation today, the focus will be on racial and ethnic minorities. And in our third and final lecture, we will focus on people living in rural America. Before coming to law school, I was a journalism major. And our motto as journalists was that we should seek the truth and report it. For those of you who are lawyers in the room, and for those of you who are aspiring lawyers, and for any of you who are none of those but are just citizens in this democracy, I challenge each of you to adopt your own motto, to seek justice and ensure fairness. I thank each of you for attending today. Please be sure to mark your calendars for March 18th at noon in this courtroom for our third and final lecture delivered by Professor Sidney Watson, who will discuss healthcare access issues for those living in rural America. I believe that we all have the social responsibility to examine disparities and inequities in our system, to question their validity, and to seek a fairer world than the one that we inherited. I hope you will spread the word and join us for our final lecture on March 18th. Thank you.
I am Joyce McConnell, the Dean at West Virginia University College of Law, and I'm delighted to welcome you all here this afternoon, and welcome to all of you who are listening online. Today we are going to be celebrating the lecture by Professor Dayna Matthew in a series that has actually been launched and endowed by the Edward G. Donley Memorial. I want to take a moment to tell you about Edward G. Donley because he is one of our distinguished members and alums and also was a member of our faculty. He graduated from this law school in 1899 and practiced until 1952 actively. It's very distinguished in West Virginia and meant a lot to the graduates of this law school. I'd like to note that feels very special to me as one of the newer deans at this law school to be able to celebrate someone who graduated in 1899 by an endowed lecture that will keep his name and his memory alive forever. It's a wonderful, wonderful legacy that his widow and his son have left for us to celebrate his life and all he stood for. We're privileged today to have with us Professor Matthew, who also serves as the Associate Dean for Academic Affairs and Professor of Law at the University of Colorado Law School in Boulder. She started her academic career at the University of Virginia, joined the University of Kentucky faculty, and then joined the University of Colorado faculty in 2003. She catapulted to the position of Associate Dean for Academic Affairs, and the reason she's laughing is because those of us who have served as Associate Deans for Academic Affairs often think of it as punishment as opposed to a reward. But she has been teaching in that role as well and continues to teach evidence, health law, including health finance and administrative law and medical malpractice litigation and ethics. I learned last night that one of the things that she said about Boulder, it's a place where people drive $500 cars with $5,000 bicycles strapped on top. And I thought that was a great image, certainly one I would share about Boulder. Prior to arriving in Colorado, Professor Matthew practiced civil litigation, where her work primarily focused on the defense of medical care providers and corporate manufacturers in state courts, federal courts, and before administrative and licensing tribunals. And she mentioned to me in conversation that she had spent much time actually in West Virginia in the federal courthouses. So she has been to Bluefield, Charleston, Wheeling, and Morgantown. And we're glad that she was familiar with our great state. She graduated with an AB in economics from Harvard-Radcliffe and obtained a JD from the University of Virginia, where she served as the editor of the Virginia Law Review and won the law school's 2-year Lyle moot court competition. She also taught as a Hardy Dillard Writing Fellow, and following graduation, she enjoyed the privilege of clerking for the Honorable John Charles Thomas, who was the first African-American justice to sit on the Virginia Supreme Court. Professor Matthew has written articles on health and antitrust law topics, which have appeared in the Virginia Law Review, Houston Law Review, Wake Forest Law Review, Indiana Law Review, the Kentucky Law Journal, and St. Louis University Law Journal, as well as the American Journal of Law and Medicine. Please join me in welcoming our very special guest today, Professor Matthew.
It's awfully nice of you. Whenever I hear an introduction about myself, I wish my children were here to listen, because mostly when people say, Professor Matthew, my kids go, who are they looking for? Is that Mom they're talking about? So thank you for this warm welcome. I have spent a lot of time in the state of West Virginia. And I've driven down, well, I'm going to date myself because now I think 68, it was 58 or 48 when I was driving, so that's how old I am. But it's a stunningly beautiful state. And a look at your website tells me also that there are some stunning things intellectually going on at this university. The faculty that I met last night are all doing incredible work. And just looking at the series that Brandon Stump and the editorial board have put together, and just taking a glance at some of the talks that are coming up, the Journal of Gender, Race, and Justice, the symposium that's being done, and your very, very recent successful graduate, Judge Irene Berger, returning to the state. There's so many vibrant things and so many progressive things going on here that I hope you will not find my comments today to be too outlandish. I've decided I'm going to give you guys the full Monty. You're going to hear how outlandishly I can think about this problem of healthcare disparities. So I heard that some of you have classes at 1 o'clock. I'll speak quickly because I really want to get to the controversial part so that you guys can come to this mic and attack my ideas. So I'll start by quoting Dr. Martin Luther King, who said that of all forms of inequality, injustice in health care is the most shocking and the most inhumane, and I must absolutely agree with it. It's shocking that in the 21st century we still see such disparate distribution of health care and have it appear along racial and ethnic lines as it does, and it appears not only pervasively, but it appears to be okay. It appears to have lots and lots of people explaining why in the Obama era, since we have the 44th president of the United States, a black man in office, it must not be racism. It must not. We're in the post-racialist society, as I've been talking about some this morning. That to me is shocking. It is inhumane to think that of all the gifts, good health is absolutely essential to participating in any other facet of the American dream. One could not compete for housing, education, or any other benefits of the American dream if one does not have the basic, fundamental, good health that, in fact, we have the scientific ability to confirm. So it's indisputable that this inequality and this injustice is inhumane. My goal this afternoon is to propose a legal model that will address it better than the law that currently addresses this problem. I want to proceed in 6 parts, and that shouldn't scare you because I'm going to go pretty quickly even though it's 6 parts. I want to first define health disparities so we understand and are on the same page about what it is that I'm describing. Here I will acknowledge that there are multiple sources of health disparities. That'll be part 2 of my speech. And that we are talking about something that is multivariate. There are lots of levels and lots of sources. But I will be talking about 3 levels and 3 sources in part 3 of my talk. I will be talking about treatment disparities, things that happen because clinical decisions are disparate between whites, blacks, Latinos, along racial and gender lines. Secondly, I'll be talking about patient-level disparities, things that happen because patients are ill-informed based on their race, gender, and ethnicity. And thirdly, I'll talk about systemic health disparities. All of these, I hope to convince you, have a legally cognizable axis. That is to say that there is something the law ought to do about these things. It's not because people have different diets. It's not because they choose not to exercise or they don't watch their weight, things the law doesn't take into account. But that they have, in their instance, a reason, the law has in this instance, a reason to care and a reason to act. I'll go next to the traditional legal solutions and show how they are insufficient. And that will give me permission in the 6th part of my talk to introduce you to the fiduciary medicine model, which is my proposed solution to handling some of these legal problems that I hope to highlight. So let me start now, as I promised, with part 1. Racial and ethnic disparities are defined as differences in health, outcomes, status, care, that are not due to differences in clinical needs. They're not due to differences because people have a different family background, a different diet, a different personal regimen. They're not due to preferences, and they're not due to the reasons that might obtain when physicians or other providers simply choose the appropriate interventions for people along different axes. Rather, these are differences that are due to the operation of a healthcare system in a regulatory climate that pervasively accepts discrimination, that pervasively accepts discriminatory communication, and that could be solved if this discriminatory element was addressed by the law. So the evidence that this discrimination and that these disparities exist, we actually could spend the rest of the afternoon on, and I'll show you just a few slides to set the tone. Using the 2000 census, which will significantly be different from the 2010 census, but using the 2000 census, remember that if you are looking at the total population, the percentage of Hispanic or Latino members of the American population at 11%, or African American members of the population at somewhere around 11 or 12%, makes that population, by definition, a minority population, right, as compared to 72% of Caucasian members of the American society. And this, again, is the 2000 census. So understanding this representation of society, when you look at indicators such as life expectancy or infant mortality, those health outcomes are disparately distributed along racial and ethnic lines, and they are disadvantaged. These outcomes show disadvantage. So just a couple of examples for minorities. If I am born black and African American in America today, look at the difference between the number of deaths per 1,000 live births overall that African American babies experience as compared to white babies born in the United States. And in certain parts of the United States, urban centers particularly, this infant mortality rate is not only more dramatically negative, but it is comparable to the infant mortality rate in some of the emerging countries, developing countries like Haiti, right? And I could do this for life expectancy. In looking at all the leading causes of death for all ages in the United States, heart disease, cancer, stroke, unintentional death caused by traumatic injury. If I go to each of those categories in turn, you will see repeatedly the pattern that racial and ethnic minorities suffer death by these disease modalities far in excess to and disproportionately more frequently than white Americans do. So I'll just run through a few of these. As I say, we could spend the rest of the afternoon on this. And I'll pick on my state. I thought about switching these to West Virginia, but I thought, I'm a guest, and I've lived in the South long enough to know that you don't come to somebody's house and put your feet up on the table. So I'm going to show you how bad it is in Colorado, okay, my home state. So I can look at cerebrovascular disease, death by stroke, right? And you'll see now that all you have to do is scan across the bottom, and the highest bars, male and female categories, are going to be African Americans. The next highest bars typically are Latino Americans. Breast cancer. Now, breast cancer is an interesting one. We could spend a lot of time on this one because one of the reasons that the incidence of death recorded by breast cancer, due to breast cancer is so high among white American women is because they are more able to access mammograms and get diagnosed more frequently. And so the recording is higher. But still, the death rate among African Americans exceeds those among other races. Similarly, in Colorado, age-adjusted, death by heart disease, cerebrovascular disease, cancer of all sorts, including breast cancer. You're beginning to see a pattern, are you not? Latinos and African Americans run neck and neck in Colorado dying due to diabetes. HIV/AIDS, off the charts. Doesn't matter which of the 50 states you choose, death racially skewed out of favor of racial minorities. These status symbols are unrefutable. Now, let me also say, again, I could do this for a while. I just recently read some very compelling literature about death and access to health care in nursing homes. Admissions to nursing homes for African Americans, much lower. Delay in transfers, much higher. Substandard facilities, when one looks at the facilities that African American elderly live in as compared to white Americans, substandard cleanliness. Transfers to hospitals due to disease, much slower, and the incidence of bed sores. These are studies that have recently come to my attention. When you look at the reason that this occurs, it's, again, multivariate. But one of the things in Colorado, again, my home state, that's got to be figured into the picture is the incidence of uninsurance. That is, the number of people of color who do not have access to health care because they are uninsured. Latinos and African Americans leading the way as compared to the number or percentage of population of whites in the state of Colorado. So that's the evidence of what I'm talking about with respect to health care disparities. Let me turn now to part 2 and talk to you a little bit about the sources of these disparities. Now, I am willing to admit by showing this chart that the disparate outcomes, the disparate kind of data that I have described to you has several sources. There is a part of the problem that is non-actionable, that is to say, that is not of legal moment, that I don't ask the law to do anything about. And by showing you this slide, I want to acknowledge that there are communication problems, interpretation and compliance issues, personal behavior and diet issues, stress issues, and so forth, that may lead to the far right-hand side of the chart, which is racially disparate clinical decisions. So I am acknowledging, and I invite you not to come up to the mic and tell me this is a very complicated problem. I know it's a very complicated problem. But I do invite you to think specifically about those parts of the problem that are, in fact, motivated by discrimination. And if you'll allow me some time, I will prove to you that that discrimination need not be maliciously motivated. In other words, you don't have to be a bad person. You don't have to be a bad guy in order to make racially disparate decisions that yield up the kind of health disparities that I'm describing. So again, I acknowledge that there are treatment-level variables that the law cannot act on. I acknowledge that there are patient-level variables, and I acknowledge that there are health systemic-level variables. But I argue to you that those variables that are legally cognizable are not only pervasive, but I would argue are the most influential. If we want to put a dent in health disparities, if we want to change the inequality and the injustice that I'm describing, then the law needs to get busy and do something about the kind of discrimination that's occurring at 3 levels. So let me start by talking about treatment-level disparities. I'm going to show you very quickly a study that rocked the medical world. I mean, it was done in 1999, and the amount of literature that has been generated beyond the number of trees that have been killed has been phenomenal. Why? Because it was one of the most pervasive, one of the most convincing showings that the kinds of disparities that I've described actually occur because providers, physicians, make discriminatory treatment decisions. So we had known for quite a long time that African Americans were significantly less likely to undergo CABGs, which are the kinds of operations my husband does, cardiovascular corrective bypass graft surgery. We knew for a long time that whites were much more likely to get angiografts. We knew for a long time that blacks were much less likely to receive carotid artery endectomies and those kinds of treatments, the imaging that really is diagnostic. We knew for a long time, but we didn't know until Kevin Schulman and his group wrote an article in the New England Journal of Medicine that was based on a study of 720 physicians who took this exercise. They watched a videotape of patients who were given a script, and each of the patients were actors, and they were only different in their race and in their gender. They were dressed alike. Their family history was identical. Their diagnostic tests were identical. Everything about their physical health and family records were identical. They were asked, the physicians that is, were asked to make treatment recommendations. And as a result of their treatment recommendations, the data that was collected showed that the likelihood of getting best practices, that is being recommended for the best types of treatment, catheterization in the case of this carotid artery disease example, the likelihood was driven by race and gender. That is to say, if one was black and female, one was 40% less likely to get recommended for cardiac catheterization. And that was the most influential driving factor as to whether or not one would get that treatment. So the results and the conclusion were that race and sex of a patient independently influenced how physicians managed chest pain. This, of course, was explosive because it said that it's not only diet, it's not only exercise, it's not only family history, it's not only environmental kinds of factors, but it is the fact that treatment decisions are different. These are physicians who go into the practice of medicine to be helpers, to be beneficent, to be good in what they do. They don't intend to be bad people. They don't intend to be racists. The number of times that this has been duplicated by studies in Utah, one in Colorado and elsewhere, has made it such that even though the conversation has been about whether we should have used odds ratios or risk ratios and other things, that the Schulman study group at the end of the day said, look, I don't care if you quarrel with whether 40% or 30% or even 20% was the right number. The fact of the matter is that these disparities, the lower utilization rates for best practices, cannot be explained by a desire to give better health care to people of color, right? So we can quarrel about the numbers, but we know that at bottom, this is about disparate decisions, and that is unacceptable. I have to also mention a study at the bottom by a Dr. Green at Mass General Hospital that makes use of something called IAT technology, implicit association tests. And those tests are just now showing what Brandon referred to in the introduction to my speech, that lots of these choices that doctors are making on disparate bases that are yielding up the kinds of discriminatory outcomes that I described earlier, lots of them are unconscious, right? Again, one doesn't have to be a really bad person. One doesn't have to be a racist. One does not have to go and participate in Ku Klux Klan rallies in order to make the kinds of decisions that ultimately end up yielding up these wide and wild disparities in health care. That's important because when one thinks about what the law can do, turning now to the fourth part of my talk, when one thinks about what the law can do, I want to suggest to you that what we have in the way of existing tools is not enough. What we have used in the past in order to address pervasive discrimination is not enough to talk about the kinds of bias that currently operate. I've talked about patient-level disparities. I'm going to talk really briefly about treatment-level disparities and system-level disparities so that I can go to the remedy or the solution that I propose. The example of patient-level disparities has to do with informed consent. And if you've taken first-year torts, you've had the case Schullendorf versus Society of New York Hospitals, in which Justice Cardozo says the right to determine what shall be done to your own body is a human right. It's a basic human right, right? And if you know anything about informed consent, if you've gone to the doctor, if you've gone to the emergency room, before you get any treatment, you have to give, 1, your insurance card, and 2, your informed consent. You sign a paper that unless you've gone to law school, you're not, maybe if you've gone to law school, you're not likely to read the entire because you're hurt or you're bleeding, you just want care. So what you basically say is, I agree, and in making my signature and putting my signature this way, I am informed, I understand that I am giving you my consent permission to touch me, to treat me. Otherwise, the person who treats you could be sued for battery, right? Unpermitted touching. So informed consent is a concept that's familiar to you. And the Schullendorf case points out that in the American context, informed consent is all about autonomy. It's all about one's individual right to self-determination, right? You cannot find a Schullendorf in the jurisprudence of China or Taiwan, right, for example, because this notion of autonomy and self-determination and the right to control one's own body is a really distinctly American concept. That means also, as social scientists have confirmed repeatedly, that it is a distinctly Western white concept, right? Social scientists have repeatedly shown that ethnic minorities, and oddly, religious minorities, right, don't share the notion of autonomy. And so the law that is constructed to protect patient-level autonomy, patient-level decision-making, frankly doesn't work with respect to minority patients, with respect to racial and ethnic minorities. And a very quick story just to tell you that the current law not only operates disproportionately, but it yields up disparate outcomes. It is part of the reason that the data I showed you at the very beginning of the talk exists, part of the reason that the disparities exist. So not a hypothetical at all, but to go through it quickly, I style it for you as a hypothetical. First-generation Chinese patient, right, has been diagnosed with small cell lung carcinoma. And his family, in the initial conference with a residence in a university, large university town, large university hospital, sits down upon hearing this and says, thank you for sharing the information, but you may not share it, please, with our loved one. Don't share it with the patient, right? Don't tell the patient that he is terminally ill. You tell the family in our culture. You tell the community in our culture. In fact, it is rude to say to a patient, you take away their hope, you take away their prospects for getting better, and you deprive the community of taking care of and providing comfort for this patient. It is actually culturally abhorrent to tell a patient in our culture that they are terminally ill, right? And as I say, I'm styling it as a hypothetical, but this is a true and very, very commonly replayed contradiction, if you will, between our legal system and the cultural reality of ethnic and racial minority patients. Fast forward to the fact that the resident understands the law in the United States to say, informed consent requires me to say, here's the treatment, here are the alternatives, and here is what happens if you do nothing. Otherwise, I am exposed to liability for a negligence action based on my failure to properly consent. Understanding that to be the law, right, announced in Schulman, the resident in this hypothetical refuses to comply with the family's wishes. Well, you can see how this arrangement quickly erodes. The family bars the resident and his staff from seeing the patient without any family members present. Ultimately, they decline diagnostic biopsies. Ultimately, they withdraw their very young family member from the hospital against medical advice, and he's lost to follow-up. We do know that he died without palliative care, without having a biopsy, without any kinds of chemotherapy or radiation intervention. And this I trace to a misunderstanding and miscalculation of our law with respect to minority and racial and ethnic minority patients. This gets played out repeatedly and yields up the kinds of health outcomes that I described. So what do we do about systemic level disparities? Systemically, African Americans, Hispanic Americans, and Asian Americans are disproportionately represented among the poor, are disproportionately represented among the uninsured, and therefore, as a result, have disproportionately poor access to health care. Very quickly, some of the evidence, and I'm sure this is familiar to you anecdotally, so I won't spend a lot of time lingering on the fact that if you look at those below the poverty level, they are disproportionately young and disproportionately brown and black. If you look at those who are uninsured or have been uninsured for any length of time, again, they are disproportionately young and disproportionately brown and black. And systemically, what that means is that if you look at those who have no usual source of health care, that is, don't have access before they go to the emergency room, no preventative care, no regular follow-up, no well baby checks, and so forth, they are, again, disproportionately poor and disproportionately brown and black. This is what I mean by systemic or access to health care disparities. The traditional legal solutions that I'd like to turn to now have to do with addressing intentional race-based decisions. The treatment level, the patient level, the systems level disparities that I've talked about to date at this point had been handled long ago by the civil rights law, which was potent and in many ways very effective. The segregation that used to obtain in hospital settings was effectively dealt with by civil rights laws in cases such as the case that famously turned history, quite frankly, and led to Title VI, if you're familiar with it, styled Simpkins v. Moses. It's a 1963 watershed case in which 6 African-American physicians, 3 African-American dentists, and 2 African-American patients challenged the refusal to admit or grant privileges at Long Hospital and Moses Cone Hospital in North Carolina. The allegation on the part of these plaintiffs was that the Constitution's 5th and 14th Amendment were violated by this refusal of privileges, as well as the Hill-Burton Act, which you may know financed the construction and renovation of most hospitals around the country up until very recently. Well, the spending principle means that the government could, and the court did, in this instance, hold for the plaintiffs. and said, you know what, the massive use of public funds and the consequences of discrimination concern health and life themselves and therefore are actionable. When the Supreme Court refused to take cert on this case, that sent a very strong signal to Congress that it was, in fact, not appropriate to apply separate and equal to hospital and healthcare settings, right? So these kinds of scenes that were necessary to desegregate schools and to desegregate lunch counters and to make it possible for me to stay in the waterfront hotel, the beautiful waterfront hotel, or to come and speak to you today, you never saw the marching and the fire hose and the dogs and the demonstrations. You never had to see that in order to desegregate hospital wards. It didn't have to be done. And the reason it didn't have to be done is because we had the power, the spending power of the federal government to say, if you want Medicare funds, if you want Medicaid funds to reimburse the care for patients, then you will have to do it on a non-discriminatory basis. And actually, the Simpkins v. Moses case in 1963, if you read the legislative history of Title VI, was instrumental, was dispositive in convincing Congress to pass Title VI of the Civil Rights Act of 1964. Now, the language of that act looks like it ought to work, right? The problems I've been describing, it should be that the statute that says no person in the United States shall, on the ground of race, color, or national origin, be excluded from participation in or denied the benefits of or be subjected to discrimination under any program actively receiving federal financial assistance. The large dependence in this country on Medicare dollars and reimbursements, the large dependence on financing by the federal government, that should solve the problem, right? But if you've taken constitutional law, you know that that doesn't work anymore. It doesn't work very well at all, since the most effective cases being brought or to be brought, available to be brought under Title VI, are no longer available as private causes of action. And all that remains is an administrative layer of enforcement to prove disparate impact, right? To prove that the effect of a decision to relocate a hospital out of an inner city and into a suburban setting, the effect of a decision to provide care to a white population on a basis that's different from that for a black or Latino population. Those kinds of cases are no longer available to private citizens and can easily be defended on the basis of economic defenses and other types of explanations that are cognizable by the court, making the civil rights law pretty much ineffective. Add to the fact that if you remember what I said about the Schulman study and the informed consent biases, those don't necessarily arise out of intentional discrimination. And intentionality is one of the elements that is required in order to raise an effective claim under the Title VI regime. I could spend some more time telling you why tort law, medical malpractice law, the law of informed consent, these are insufficient also. But I think you quite get the picture that the existing legal regimes that we have at our disposal really don't get at the kinds of problems that have yielded up the disparities that I have described. So for the last couple of minutes, I'd like to lay out something I call the fiduciary medicine model. Hold on to your chairs, because if you took corporate law, if you take corporate governance, agency and partnership law, I'm about to use that law in a way you probably have not been exposed to before. So agency and trust law conceives of a fiduciary relationship as one that arises when a fiduciary, a person in power, a person who is knowledgeable, undertakes the duty or the obligation to act solely for the benefit of a beneficiary, a person who is vulnerable, a person who is less knowledgeable. The fiduciary relationship is created in several ways. Often it's created by the transfer of property. Aha, the first problem with my model, right? What property is transferred when a physician undertakes to care for a patient? I have an answer, right? It also is the case that a beneficiary can entrust to a fiduciary control and management of something of value. What asset would that be? What property, again, would that be? A fiduciary relationship arises when someone is dependent upon another, when someone is vulnerable to another. Examples that you might have heard of before are corporate directors who are fiduciaries for shareholders, employees who are fiduciary agents of their employers, partners to a partnership are fiduciary and stand in a fiduciary relationship to one another. Banks stand in a fiduciary relationship with borrowers and even with depositors, and so on. Here I conceive of the fiduciary relationship on two levels. First, the easiest, on the physician-patient level, where I think it's pretty easy to see that the physician fiduciary has a duty to act for the sole benefit and in the best interest of a patient, right? The relationship is created, as any agency relationship is created, when the patient, the agent, entrusts to the fiduciary as principal their health, their well-being, and their access to non-discriminatory health care. That's a property interest, I argue, and will convince you in 2 minutes of. The patient beneficiary entrusts the physician with control of his most valued asset, control of her health, control of her well-being. The physician's knowledge is superior, despite the fact that the information the patient has about themselves, their family interest, and their history and their background, is superior. The scientific information is superior on the part of the physician. The patient is vulnerable. Not only is this information asymmetry vast between the patient and the physician, but the patient can't adequately monitor what the physician is doing, right? I go, I have a chest pain, and I ask for help. I don't know whether I need 1 jump or 2 jumps in the cabbage you're about to do. I'm going to be out when you operate on me. I have no way to assess or monitor whether you're acting in my best interest or not, right? This, I argue, is a classic fiduciary relationship. Moreover, I'm dependent wholly on your beneficence. Most importantly, I'm depending upon you, the physician, to do exactly what the Hippocratic Oath promises, right? So for those who might be physicians or aspiring physicians in the room, I'm not suggesting that the law heap upon you a new set of duties. I'm suggesting that the law be updated to reflect the duties you actually, as a provider, already agree to undertake. After all, the Hippocratic Oath says, I will apply for the benefit of the sick, beneficence, all measures that are required, avoiding those over treatment and therapeutic mistakes. I will remember there is art to medicine as well as science, and that warmth, sympathy, and understanding may outweigh the surgeon's knife or the chemist's drug. In so promising, my argument is that providers agree to stand in a relationship that requires them to exercise exactly the legal duties that we are very willing to enforce upon corporate directors. The duty of good faith, the duty of the highest standards of honor and honesty. In the same way that the prudent investor rule requires a trustee to make not only appropriate investments, but to take into account the entirety of a portfolio, of an economic environment, I'm arguing that we should impose upon, rather than negligence and battery principles, physicians, those duties of good faith, honesty, the duty of loyalty, that is familiar in trust and agency law, should also be imposed in order to require the exercise of due diligence, best efforts, and prudence on the part of physicians. The continuing duty to supervise trusts would require, if we hearken back to the Schulman study, that a physician not only look at his or her decision with respect to catheterization for an individual patient, but become familiar with the entirety of the disparities that are resulting in the healthcare delivery system in America and act to prevent those as part of their entire and continuing duty, not just to one patient, but to the public health in general. I argue that the resident who worked only to make sure that informed consent disclosed the alternatives and the terminal illness out of the abiding principle of autonomy under our informed consent law would act differently if asked to act for the sole benefit of a whole patient out of discharge of a fiduciary duty. That resident would have inquired first, who do you want to be your decision makers? What is reasonable in your community, in your cultural setting? And what should be my responsibility with respect to your holistic values as a patient? When you apply these duties, the good faith effort on the part of that resident would have resulted not in a mechanical execution of an outdated and limited version of informed consent law, but it would have required that resident and would have obligated the hospital in which that resident operated in to pay attention to cultural differences. Now, in the last 2 minutes, I'll tell you that if you buy this model on the patient and physician level, I'll push you even further to suggest that on a systemic level, the United States government is actually fiduciary for a property interest in health care that is created as a social good. And the proof of that is the extent to which, if you hearken back, I don't know how many of you have read Charles Reich's famous article from 1964 called The New Property. I use that new property argument to suggest to you that when a government takes in revenues, right, nearly 16% of our gross domestic product is spent on healthcare delivery. When a government takes in revenues and dispenses out money to finance reimbursement for health care to providers. We do have universal health care in the United States as long as you are 65 or older, right? Independent of your wealth, independent of your race, you are covered at 65. When the government finances research and development, when the government licenses health care providers, when the government allows patients to deduct their health care premiums above the line or allows a subsidy to give employers the benefit of dispensing health care benefits before they are required to calculate their taxes, then the fact is that the franchise of delivering health care in the United States is the franchise of delivering a public good financed by the public fisc. It is my argument that that property interest is entrusted to the government and therefore has to be distributed to the common and for the common good of all members of society, right? That the principles of justice, equality, non-discrimination that are dear to our democracy are absolutely imperative to superimpose upon the property interest in health care that is generated by the investment of the public fisc, your dollars and my dollars. And that is as compelling, in my view, a reason for a governmental address to universal health care and a systemic address to the problem of disparities, as Professor Kinney's human rights argument, with which I also identify. In closing, let me say that I think the strength of this model is that it adds to the entitlement theory of health care, an entitlement based on the labor and investment principle, a Lockean principle, if you will, of property. That property is owned by me, it's owned by you, and we can compel our government to distribute it fairly. So there you have an application of fiduciary responsibility that I bet you never thought you'd hear. Thank you for listening.
We're going to do questions and answers at this time, so if you have any questions, please come down to the microphone. And don't say your questions or you actually stand in front of the microphone because we're trying to record everything. So
Thank you so much for coming here today. Your talk was very interesting. My question is, if we buy into your fiduciary model of healthcare distribution, how do we as litigators and members of our community go about enforcing it? Do we attempt to bring suit under the Civil Rights Act? I know you mentioned that that is largely ineffective in some ways, or do we try to make changes in the laws of our country? What do you think is the best approach for implementing your model?
Great. I thank you for the question, because I started flipping pages quickly. It's the part of the model that I didn't lay out. The fastest way to get this model implemented is to enact a piece of legislation that is very much like the prudent investor law that operates to provide and define fiduciary relationships between corporate actors. So the Prudent Investor Act basically is very short. It's a 2-page act, and it basically outlines the duties that I've described: good faith, loyalty, beneficence, sole benefit, lack of conflict of interest, and so forth. It outlines those for those who stand in a trust-trustee relationship or an agent-principal relationship in corporate settings and in several corporate settings. I'm asking or suggesting that in order to implement this fiduciary model, that the quickest way is for either a federal level or a state level enactment to mirror that investment rule for medical care. That would be a really easy way to allow litigators in courts to go ahead and enforce now and give scope to the duties and obligations that I'm describing as good faith, beneficence, and so forth. Alternatively, let's just say that Congress doesn't get out of the logjam that it's in right now, right? Alternatively, what I would like to see is that plaintiffs in informed consent cases start highlighting the rich data that says, you know, that informed consent law that we've been working with since 1914, not only is it inappropriate and ineffective, but I'd like to argue a novel a notion of fiduciary responsibility and begin to lay out for courts reasonable extensions of existing law, right? This is existing law. We have lots and lots of interpretations of what good faith duties and loyalty duties look like, but reasonable extensions of this law to the medical context. Here's why you won't get laughed out of court. There are a number of cases that already do this, especially where informed consent is concerned, especially where a confidentiality issue arises between a patient who gives confidential information to a physician and that physician is subpoenaed to testify in the context of as an expert. Courts have already said, you know what, there is this fiduciary kind of relationship between physicians and providers. I suggest that this is a reasonable extension of that already present law.
Hi. As Chelsea said, thank you. I've really enjoyed the speech. My question deals with, without getting into too much detail, at the treatment level of the fiduciary model, who would the duty be owed to on a patient level in the context of minors or incapacitated patients? Would it be much like a lawyer owes to a minor client, or if you could address that?
Generally, I conceive of the duty as being owed to the patient at the treatment level. And a minor stands in a special relationship because that minor is particularly vulnerable, right, and particularly ill-suited to monitor and control the acts of a physician. The fiduciary concept requires the fiduciary actor, in my model, the physician, to act in the best interest of the patient. And that would be the whole patient, taking into account the patient's youth, as well as the medical indicators that physicians and other providers are familiar with. So I would say the answer to your question is that the fiduciary obligation is owed to the minor, but also owed to those who are responsible for the care of the minor. And so that would have to include the whole view of a family, of a cultural setting, of a community.
Thank you for the provocative talk. The question I have, let's assume that for the most part I buy into your solution, I buy in that there's a problem, and I do. The question I have is, how much of the problem will be solved by your plan? It seems to me that the two things you showed were interesting. Number one is the high levels of poverty, and it seems to me that poverty is the number one cause of health disparity in America. I suspect if you looked at West Virginia, you would see a disparity based more on rural areas than on race, just a guess. And then second, something I thought that was very interesting was that Hispanic Latino populations have 3 times the uninsured rate, yet actually they were only higher in incidence for health on one of the slides. For every other one, it was lower than Caucasian. And so given that it's 3 times more on uninsured and yet less on incidence rates, it makes me wonder whether poverty and community, lifestyle, all the other complex factors you raised will be most of the problem as compared to physician treatment disparities.
So, great question. Let me take from the back end first. Let's talk about there is a phenomenon in understanding the health gaps of Hispanics. And I'm going to address that, and then the end will be to say that while poverty is an indicator, even if I control for poverty, socioeconomic disparity, and uninsurance, there's still a vast amount of discrimination that is only explained by race and ethnicity. The Hispanic population is really quite interesting because they are a population that only displays health outcomes at a disparate level if they've been in the longer they've been in the United States. Okay, so first-generation immigrants, notwithstanding poverty, notwithstanding uninsurance, notwithstanding the fact that their socioeconomic indicators are worse, actually end up with better outcomes if they've only been here for a short period of time, right? The longer you stay in the United States, the more you start to mimic the type of disparate outcomes as a Hispanic population or a Latino population as African Americans, Asian Americans, and others mimic. And that's a phenomenon that there are lots of explanations for. First, the stress of living in a society that is racially biased, right? That will stop you in a car if you're brown and do different kinds of background checks on you when you apply for a job and give you a different level of access to health care based on whether or not you are able to prove your immigrant status. That helps to change your health outcomes, right? So even though I'm poor and living in a farm in my home country, I'm not afraid for my life, and I'm not being threatened with deportation, and I don't live the kind of stress. That's one explanation, but there are lots and lots of people wondering about why it is that exactly what you're saying for Latino Americans, the health outcomes look really good as long as you stay here really only for a short period of time and get back to your home country. But the longer you stay here, the more disparate your health outcomes end up being. The Schulman study that I showed you, as well as the ones that replicate those outcomes, control for insurance, control for poverty, control for socioeconomic disparity. And while you are exactly right on a systemic level in West Virginia as well as in Colorado, I have a slide from Colorado that shows that access to health care in rural settings is so disparate that the outcomes have to be impacted, right? It has to be the case that if you have only got one tertiary care university level hospital in a 100-mile radius, and that's your only access to that level of health care, or you only have one dentist in 6 counties or 2 physicians in 8 counties, then your access to health care is going to be a determinant based on the rural nature of your setting, and that will have a huge impact. Remember, I said I'm not talking about the only impacts. But when I do control for socioeconomics, when I control for disparate insurance levels, and when I control for poverty, I still am able to come up with numbers like the Schulman numbers, right? That disparate decisions are 40% more likely based on race and gender alone. My regression analysis results in a finding that that's the best predictor. Not my insurance, not my income, not my poverty. So I have to disagree with you in this way. If I am able to handle race bias, if I'm able to handle ethnicity and cultural bias, I think I hit the largest part of the disparate impact that I've described. Not the only, but the largest.
First off, thank you, like everyone said, for being here. We really appreciate it. I actually don't have a question. I have 2 brief comments, and for those who know me here, probably be surprised when me say brief. Me speaking is very rarely brief. But first, with the evidence section, I found it just resounding that with such a disproportionate majority of whites in this country, that I would assume at least, that whites would lead every category because there are so many more whites. And because of the fact that whites don't lead all categories, it makes the evidence even more shocking that it's obviously disparate to me. Secondly, there was only one thing you said I disagreed with for a little comedic relief, and that is you said the operation of the healthcare system. I would call it the inoperation of the healthcare system. Thank you.
Duly noted, Counselor.
I think that we're going to probably end the lecture unless anybody has any final comments. So thank you, Professor Matthew.
Thank you very much.